Welcome to whoever preparing for any cross examination or legal point of view in examinations. What is the importance of a cross examination in a case, whether it is a case or a suit or any other proceeding? What exactly the cross examination make real difference in respect of defending the case where an issue is framed in a civil suit. Broadly, if we take, there will be a criminal case and a civil case. There are other cases also where cross examinations are involved. But presently, let us try to understand, most importantly, that what is the importance of cross examination and what is the art of cross examination, that what are necessary things which are very important to know in the cross examination. The first and foremost point in the cross examination, it is necessary to understand the entire case or suit or other proceeding. Second, it is very necessary to know and understand what should not be asked to the witness. What we should not ask to the witness is the primary and fundamental question. Fundamental learning has to be made. Sometimes if a question is put to the witness, if that is going against the interest of the answering of the main litigation, the case goes against the person whom you are defending. Therefore, in this respect, what are not to be touched? Then if that is the case, if something cannot be touched, then what can be touched? What statute is saying and what constitution is saying in respect of this? The Constitution of India is saying and guaranteeing every citizen that if there is a case, a criminal case has been instituted, a right of defense is there. When right of defense is there, a person is defending a charge levied by state or any private person. If there is a right of defense, that means a person who has filed a case has to establish the proof of fact or evidence against the person whom they are making an allegation. That is called, the burden of proving the allegation will be with the person who is making a complaint at first stage, whether it is a state or other person. The burden of proof in sense, suppose if it is a case of 302 of IPC, case of murder, what are the necessary things which will make a case to stand before the court of law, or court of law will receive it in the form of a charge sheet and then frame the charges against a person, then commence its trial, or some things are very essential and necessary that if we call it itself as 302 murder case, who is the person who is being murdered is the essential thing that has to be explained and established with the prosecution. Unless and until the person who has been killed and identified it is for this. Now, the prosecution has to also say whether it is a case of eyewitnesses or circumstantial evidences or by other any means or relatively any collateral damage. Because there will be sometimes a fight between two groups. In one group, one person may die. In another group, another person also may die. There will be a case of 302 in this side and 307 because that person may not die on the spot at the instance. He may be admitted in the hospital. Then at the point of that time, the person may be deteriorating, and before he collapses, that person may give a dying declaration also. That dying declaration also will play a very vital role while establishing a murder case, a 302 case. If this is the rival contentions, the first and foremost thing that in the cross-examination, to know that what was the motive behind any such occurrence. The preparation of cross-examination has to revolve around what is the motive for the purpose of killing, of attempting a person, whether it is an attempting on a person, knowing well that that attempt will lead to murder. These are all relevant things where a preparatory method has to be prepared in the form of a notes. If that is the case, first and foremost thing is that the motive has to be thoroughly studied and put forth to the witnesses in the form of cross-examination. That if the motive is not established, then the burden, whatever the prosecution tries to establish, if it is not established, if it is being ousted by the way of a cross-examination and art of the cross-examination, and one witness speaks about one nature of motive and the another person will speak about another nature of motive, that may not be conjunctive evidence at all. That may be different. That may be not matching with each other. All these things are art of cross-examination in respect of evaluating the motive. Then preparation. And what is where finally the crime has occurred. These are the essential points which are to be noted while dealing with the matter in respect of, broadly in respect of prosecution and defense. Only for the purpose of example, we have seen today that in respect of a 302 case or a murder case, what are the minimum things which are required to establish and also to counter. We will see in the coming sessions very thoroughly that what type of cross-examinations are necessary to commence in respect of various offences and other proceedings. Take care.